Hi friends, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Here's what we're discussing today. Several of the cases that have been tried in the last couple of months have been real tutorials on how to cross-examine a witness. But probably some of the best cross-examination I've seen lately has come out of the Young Thug trial, or the YSL trial if you prefer. It's a trial that involves a RICO claim. Now, a RICO claim is racketeer-influenced corrupt organization, and essentially it's putting an organization on trial through its individual members, and individual members also on trial for the same things that the organization's on trial. And as a result, the trials themselves become nearly unmanageable. And I think the Young Thug trial has become pretty much unmanageable given the way that it's being handled. Now, the state has a lot of information that it has to prove. It has to check off a lot of boxes in order to get a conviction. And it has not really given the jury any kind of roadmap as to where they are going to check off all of these boxes. And the opening statement was reasonable, I guess, but you really can't have much of an outline that you can do on opening statement for a RICO case other than broad brush. And it doesn't get down into each of the individual elements for each of the individual players in that case. So a lot of the cross-examination that has gone on essentially to paint the detectives and some of the patrolmen involved as liars. And there's a big difference between being mistaken and telling a lie. I think it's important to note that. I think the prosecution has done an abysmal job of managing its witnesses. I think it's been done an abysmal job of presenting the evidence through these witnesses. And the one big failure that it has had is that it has failed to be crisp. This is not a case that you could try in a week or a month or even 2 months, and it's gone on a really long time. Part of the problem with the case is simply the huge amount of information that's going to have to be presented to the jury. And then, because there is this huge amount of information, there's a huge amount of cross-examination, much of it that does not even go to the heart of the issues. Now, why is that important? Because a confused mind always says no. If you are working for the defense, you want as much confusion as you can possibly get. And by virtue of there being a large amount of evidence that's going to be presented over many months, by the time you get to the end of this case, the jurors aren't going to remember what they heard in week 1. They're not going to remember what they heard in week 12. They're going to remember the last maybe 5 or 10 days of it with a great deal of clarity. And they might have some information from some of the other cases, from some of the other testimony in the case. But generally speaking, if you can create confusion, you're doing the right thing in terms of representing a criminal defendant. I want to talk this morning a little bit about a couple of actual examples from the Thug trial in terms of what's going on here, sort of the inside baseball on what the lawyer is doing. The key thing when you are cross-examining a witness, particularly in a criminal trial, is that you remain in control. You ask leading questions, tight leading questions, so that you can narrow the ability of that witness to run away from your question. And you ask them directly, and you do it in a calm and measured manner, and you build from one fact to the next fact to the next fact to do that. And in this particular example, the first part here, what we're going to see is the defense attorney go after this detective with regard to some information that the jury may wrongly assume is accurate as to location data. So let's take a look at that.
May it please court, Your Honor?
Yes, go right ahead, sir.
Thank you, sir. Detective Ricey, how are you?
Doing well, sir. Thank you. How are you?
I'm well. Good afternoon.
Good afternoon.
I'm going to ask you just a few questions. And I'm going to start out with 174E and 175E that was just labeled and behind you. And that is a chart that was created by the state based on your testimony, correct?
Yes, sir.
Based on historical cell records for two different numbers.
Yes, sir. CDRs.
Okay. And I just want to clarify. In the beginning, we were asking about where phones were located. Do you remember those questions?
I remember questions similar to that. Yes, sir.
Okay. In fact, these cell phone records, these historical cell phone records identify cell towers in the location of cell towers, not phones, correct?
So part of that statement is true, and part of that statement I would say is incorrect.
Okay. You can clarify.
The CDRs actually do a little bit more than that, but yes, they provide you with the cell tower location, and they provide you with a little bit more information regarding to the location of the phone as well.
Now, what you see here is the witness fighting with the lawyer a little bit. He's saying, well, you're not exactly right on that because there's other information that comes out of the tower and is in these reports that helps you pinpoint locations, essentially. But that was never where our cross-examiner was going. Watch this.
You're talking about vectors and things of that nature?
Yes, the actual cell site directions, and yes.
Okay. But when you were talking about longitude and latitude from the cell phone records, you were talking about the longitude and latitude of the location of the cell phone tower, correct?
Correct. That's what we were allowed to discuss. Yes, sir.
Not the location of particular phones.
That's correct. The specific location of the phones was not in my testimony.
Okay.
And so now the jury has to go back and think, well, now wait a minute. What were they saying on direct examination about where the phones were, and why is that so important? And if we have that, if he's not really saying that that's where the phones were, what was all that testimony about? One of the things that is really going to be a problem for the prosecution in this case is that by the time they are done with that, they are going to absolutely hate the prosecutors because all of these things are coming in and it looks good, and then prosecution rests or stops and the defense gets up and takes those points off the board. Not all of them. Not all of them, but a lot of them. And at the end of the day, when you have such a huge and complex case, like I said, a confused mind always says no. Let's watch a little more.
And what these towers indicate on these cell phone records is the tower that's utilized, the cell phone tower that's utilized by a particular phone when it's in use, correct?
Correct. The cell phone is touching or communicating with that tower, and that's what the records show.
And when you say touching, you don't mean physically touching, you mean in communication.
That's correct, sir.
Okay. Cell towers have a particular service radius. Isn't that correct?
That is correct.
Okay. Are all cell towers radius the same size?
I would say they're not.
Do you have any particular information from your testimony today about the cell radius, the service radius of any of the particular towers that you referenced in your testimony?
No, we would have to get into more particularized information from the providers than what I provided in my testimony.
So you cannot provide exact information about the distance particular cell phones are from the cell towers that you identified in that chart, can you?
Again, my testimony was limited to what I was allowed to testify to in the records that I have. We'd have to go further to get that sort of information.
Are you familiar with which towers were not in service, were not operational on April 26th of 2015?
Again, we would have to go into more information than I was testifying to today or the last few days.
Okay. Would those questions possibly be better suited for an expert in cell towers and cell phone geolocation?
Sure, they could be answered by a cell phone expert, but they would still be limited to the information that they have at hand.
And you are not an expert.
I was not classified an expert here in this court.
Okay.
So right now the jury's thinking, why didn't they give this guy this information? Why didn't he get a chance to talk about all of this? Why wouldn't you want that information if you want to know where those phones are? And of course, part of the reason is because this guy hasn't been certified as an expert in that area. And he admits as much. I've not been testifying as an expert here. I've just been testifying as a detective. But it gets a little more interesting here in just a moment.
Now, as part of your... Oh, go...
No, I was saying I haven't been classified as an expert today or the previous days here in this court. My opinion was I probably could be qualified as an expert based off of Georgia law and expertise regarding cell phones.
Okay, and I'm going to ask you, as someone who says that they could probably be considered an expert, can you give us the cell tower radius of the individual cell towers that you referenced in that chart?
Okay, again, my testimony today has been limited to those records. So if I was going to testify as an expert, I would request additional data from those cell phone providers to find out which ones are on and off, and we would have to go in depth in that manner. But that was, my testimony was not, basically didn't go into that.
So without ever calling this guy a liar and without ever using any strong language with him at all, and giving him the benefit of the doubt about being an expert, which if he hasn't been, if the court has not certified him as an expert in that area, then he can't actually testify as an expert. But he just, the lawyer just sort of blew right past that by asking him, well, if, since you consider yourself an expert, can you tell us this? And of course he says no. And the reason is because he needs more information. And now the jury is thinking, again, like I said before, why didn't they get this information? The truth may be that they have that information. They are just not going to use that information because it may cut against them in their case in chief. The art of cross-examination is that you keep control of the witness. And as you saw here, he kept control of the witness up to a point. He did let him fudge a little bit on being an expert, which is fine. He could have handled that differently, but I think the way he handled it made the jury like him more than if he had been sort of hardcore about whether or not he was an expert. They've done a really good job. All of the defendants' attorneys, when they have cross-examined these witnesses, have done an excellent job with respect to showing the things that the investigation has missed, the things that have not been that have not been followed up on. For example, if indeed they do want to position these phones in certain areas, it seems to me that the best possible way to achieve that is to go get all of the information on the cell phone towers and the locations and the vectors and that sort of thing, and use that information to pinpoint, or at least try to pinpoint, where these phones are at any particular time. Cell phones are what I would call an emerging technology in terms of being able to pinpoint where they are. And of course, many of the phones have GPS on them. Clearly, however, they don't have that information. They don't have the GPS information. And as a result, it undercuts significantly, I think, this issue of where these phones are. And of course, that's vital if you're trying to prove that somebody committed a robbery or a shooting or a murder or something like that. You have to be able to tie them to location. And of course, there is sort of this ethic in the community that this is going on in, that you don't snitch and you don't tattle to the police, and that also hampers the prosecution's ability to come in with witnesses who say, I saw Mr. A there, I saw Mr. B there, and I saw Mr. C there, because they probably want to see another sunrise. And there is a lot of there are a lot of threats that go on to witnesses in a trial where you're dealing with truly serious gangsters. And I don't know whether these guys are serious gangsters or not, but if I had seen something like this, I might be a little reticent to testify, given the fact that the crimes they are asserted to have committed are certainly pretty serious. Like I said before, cross-examination is an art, and you have to practice it. You have to have a knack at it. And these defense attorneys have done a really good job of doing that throughout the course of this trial. They have done a lot to create confusion. And again, as a defendant's attorney, if you can create enough confusion, it diffuses whatever facts that the prosecution has brought in. And particularly in a trial that is months long, these jurors are at this point getting tired of coming in and spending an entire day listening to one set of facts and then an alternate set of facts. Well, that's what I have for you today. Thank you for watching. If you have any comments, you can drop them in the comments down below, or you can email me at the address above. And if you have the opportunity today, do a kindness for someone. Doesn't have to be a big kindness. Just go out of your way and do something nice. As Bill and Ted observed in Bill and Ted's Great Adventure, which I mentioned last week in a video, they always said, be excellent to one another. And I think that's an excellent approach to life in general. And then when you've been excellent to someone else, come on back here and join me at the beach next time, and we'll talk about something else fun. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.